In this video, we introduce you to a lawsuit template found in our Tools for Justice document library. The following template is a federal civil RICO complaint for mortgage fraud, which is a genuine remedy for probably 20 million of the homeowners who were defrauded by the national banks during the housing bubble. Federal civil RICO is a special kind of statute where Congress created what is called a private cause of action for civil damages arising out of felony criminal activity when conducted as part of a pattern of racketeering. This is very, very good news for us, considering the damages that the national banks caused when they created the national mortgage crisis. During the years 2001 through 2008, the national mortgage lending industry made at least tens of millions of mortgage loans with an inflated appraisal accompanying the loan. If you were the borrower in one of these loans, then you may have been defrauded by the bank, and you may have a cause of legal action for fraud on the inducement. We invite you to learn about this issue and to determine if you have a cause of action against your mortgage lender. First, a few legal basics. The law is about rights and duties, not morality. The bank is licensed and regulated to engage in mortgage lending. The borrower is not. The bank is required to use a Uniform Standards of Professional Appraisal Practice, or USPAP, compliant appraisal to justify the loan. The borrower is not. The bank is required to underwrite the loan. The borrower is not. The evidence integrated into our complaint template shows that during the years 2001 through 2008, unscrupulous mortgage lenders and their agent brokers routinely pressured appraisers to meet the numbers in the loan docs or be blacklisted. In each of these tens of millions of mortgage loans with inflated appraisals, the bank did, in fact, use the inflated appraisal to justify the loan. In doing so, the bank misrepresented and overstated the value of the property and misrepresented and understated the loan-to-value ratio in the loan documents. This constitutes fraud on the inducement and felony criminal mortgage fraud conducted as part of a pattern of racketeering activity on a national scale. A few more basics. The mortgage follows the note. The courts treat the promissory note as a bearer instrument. In other words, the courts generally do not care about the chain of ownership to the note or who is the actual owner of the note. As weird as this may sound, in the eyes of the court, the party who produces the note is the one who has the right to foreclose. We turn the situation around to work for us and not against us. We then, like the courts, do not care about the chain of ownership to the note, or who actually may own the note. We only care about the party claiming the right to enforce the note. If there is more than one party involved, then we name them both as RICO defendants. This makes our job much easier. We just wait for a party to declare, "I have the right to enforce the note," and then we say, "Thank you. You are the successor in interest and the party whom we name as the defendant in our mortgage fraud complaint." More basics. This complaint is a claim for a money judgment arising out of fraud on the inducement, so it does not matter if you are current with your mortgage payments, behind, in foreclosure, or even if you have already lost your home. You are still legally entitled to sue for triple damages under civil RICO. Additional basics. Most causes of action for remedy associated with mortgage fraud are already time-barred, due to the statute of limitations having already run for bringing such action. We solve this problem by framing the complaint under the federal civil RICO statutes, which just happen to be exactly on point. What a happy coincidence! The federal statute of limitations does not begin to run until you discover that you have an actual injury in fact, which is specifically legally defined, and then you have 4 years from that date to bring your lawsuit. This means that if you are just now learning about this type of legal claim for the first time, you are in luck. Our complaint is written to federal RICO statement pleading standards. Thus it comes close to 50 pages, plus 250 pages of evidence incorporated into the complaint to make what is called a prima facie case, meaning that the complaint is designed to withstand a motion to dismiss, which is the usual challenge to bringing a legal claim in court. The United States Supreme Court has determined that both state and federal courts have concurrent original jurisdiction over a federal civil RICO claim. So if you are facing foreclosure in state court, you can file this complaint as a counterclaim without having to take the case to federal court. With fraud in the inducement, we have a choice of remedy. We can rescind the contract, or we can affirm the fraud and sue in tort for damages. Rescission of contract is no remedy when we owe more on the balance of the loan than what our property is worth. So we choose to affirm the fraudulent mortgage contract and then sue in tort, which means a civil wrong, for our damages arising out of the fraud. In this case, our damages are the difference between the bank's representation of the value of the property and the actual value of the property as found in the county government appraisal of the just or fair market value of the property during the year of the mortgage loan. For example, we have learned that with non-prime mortgage loans in Florida during the years 2005 and 2006, the bank representation of the value of the property in the loan documents was typically double the amount of the county appraisal of the value of the property. This means, for example, that if the county said that the property was worth $200,000, the bank said that it was worth $400,000. They both can't be correct. Throughout the housing bubble, we were all told by the national banks and their mortgage brokers that the county appraisals were way low and inaccurate. These lenders and their mortgage brokers lied to us. To calculate our damages, we take the difference between the bank's representation of the value of the property and the county appraisal of the just or fair market value of the property. We then triple this difference amount under civil RICO. This is our total damages. The loan we received is called the benefit of the bargain, which must be repaid. We subtract the balance of the loan from our damages as a set-off from the amount that the bank owes us and the amount we owe the bank. In most cases, with this type of legal claim, the bank owes us more than we owe the bank. If we still have possession of the house, then we properly seek satisfaction of the mortgage plus money damages from the bank for fraud in the inducement. Otherwise, we just seek a money judgment against the bank. After we perform our calculations, if we still owe the bank more than it owes us, then we seek judicial enforcement of a reduction in the amount of our mortgage by the amount of our damages, together with reasonable terms to satisfy the balance of the loan. In all cases, this type of settlement is far better than a regular loan modification. We also seek court-ordered repair to our credit. Our approach is not a foreclosure defense strategy, although it does have that desired effect, while going to the root of the problem to achieve our proper legal remedy for fraud in the inducement conducted as part of a nationwide pattern of mortgage fraud. We incorporate 250 pages of United States Senate, House of Representatives, Financial Crisis Commission, and other government agency reports and findings and testimony from hearings investigating the mortgage crisis, together with reputable law review articles to prove the pattern of racketeering activity conducted by the defendants and the non-party malfeasants. We then use the county government appraisal to prove the actual value of our property at the time of the mortgage loan. So, when it comes to meeting our burden to prove our allegations in our complaint of racketeering activity and our burden to prove actual calculable damages arising out of felony criminal mortgage fraud, we have the government on our side against the bank. The bank will never be able to defeat the government's own findings and testimony, and the bank will never be able to defeat the county government appraisal of the value of the property upon which the property taxes are based. The bank would, in fact, have to cross-sue the county appraiser, and that is just not going to happen. Our first mortgage fraud complaint template is written specifically for litigation in Florida. We intend to modify this template for civil action in each state and to make all of these templates available in our Tools for Justice document library. Now, on to our complaint template. This is the caption page of the template, which you can see is fillable. It's in Microsoft Word, so you can edit this document. In fact, you can use Find, Edit, and Replace to insert the appropriate information throughout the template. So we proceed from the caption page to the table of contents. And what we have here in the verified complaint is the nature of the action, the parties, jurisdiction and venue, the RICO person, statement regarding loan definitions, the RICO enterprise, statement regarding underwriting guidelines, statement regarding real estate appraisals, statement regarding loan-to-value ratios, the statute of limitations, statement regarding the statute of limitations, the alleged misconduct, the basis of alleged liability, the alleged wrongdoers, the alleged victims, the RICO pattern, deregulation enabled the RICO pattern, count 1, RICO violation involving mortgage fraud. Then there's our request for relief and verification, which makes this complaint sworn testimony, and a table of exhibits with attached exhibits 1 through 15, which, as I mentioned earlier, comes to about 250 pages. So we start out the complaint with a statement, and it says plaintiff by and through undersigned counsel, and you can see that by and through undersigned counsel is in red. That's because it's optional. If you're represented by counsel, you'll change that red to black. If you are proceeding pro se, then you just delete that portion. So it reads, plaintiff, by and through undersigned counsel, sues defendant and alleges based upon personal knowledge as to plaintiff's own conduct and upon the basis of information and belief as to all other matters. Plaintiff's information and belief is based, among other things, on documents generated by or on behalf of the defendant, which reveal the defendant's own knowing participation in the fraudulent scheme detailed in this claim. So the nature of the action. This is an action for triple damages, cost, and attorney's fees under 18 U.S.C. Section 1964C of the Federal Racketeer Influenced and Corrupt Organizations Act, RICO, 18 U.S.C. Sections 1961 through 1968, arising out of an ongoing pattern of mortgage fraud being conducted by the defendant and the non-party malfeasance in violation of 18 U.S.C. Section 1962C and Florida Statute Section 817.545. Jurisdiction and venue. This court has original jurisdiction to hear plaintiff's civil RICO claim under 18 U.S.C. Section 1964C in accordance with the decision of the United States Supreme Court in Taflin v. Levitt, 1990. This court has venue jurisdiction over the mortgage fraud conducted in connection to the subject property located in such county under Florida Statute Section 817.545(4)(a) and b. The RICO person. The defendant is the successor in interest to the party identified as the lender in the promissory note and the mortgage dated loan date. See Exhibit 1. The defendant has assumed the legal rights, duties, and liabilities that run with the promissory note. Defendant fraudulently misrepresented the value of the subject property and misrepresented the loan to fair market value ratio based upon a false and inflated appraisal overstating the property value conducted as part of a pattern of racketeering activity by the non-party malfeasance, the liar's loan enterprise. Okay, we're going to move through here to the paragraph F. The liar's loan enterprise consists of the hundreds of entities making up the national subprime mortgage industry, whose top executives operated these companies as control frauds, a financial weapon against society, by rigging financial incentives within the industry to reward a nationwide pattern of brokering, originating, bundling as securities, selling into the secondary market, servicing, and foreclosing on what the industry insiders dubbed as liar's loans, which are stated income mortgage loans made with no income verification, no or little documentation, no underwriting, a false and inflated appraisal overstating the property value, and an understated loan to fair market value ratio. The liar's loan enterprise is a subset of the national mortgage lending industry. See Exhibit 3. Public policy issues raised by the report of the Lehman Bankruptcy Examiner hearing before the Committee on Financial Services, United States House of Representatives, April 20, 2010. Statement of William K. Black, Associate Professor of Economics and Law, and we go on. Some more exhibits. We'll work through here. This is just to give you a taste of what this complaint is about and to see if you might be interested in using it yourself or if you know of somebody who needs it. Okay, we're going to scroll through to page 10. Okay, there's a statement regarding underwriting guidelines. We keep going. Oh, here we are. Now this is in a Fannie Mae publication. Fannie Mae expects the lender to place as much emphasis on underwriting the property and reviewing the appraisal as on underwriting the borrower's creditworthiness. Now with these liar's loans and other loans with inflated appraisals, does the lender do this? Absolutely not. So we keep going here. Okay, we're going to scroll to page 14. Okay, here we are. This is from a Senate publication. The Office of Thrift Supervision Investigation uncovered many instances of improper appraisals. After reviewing 225 loan files, the OTS appraiser expert found that numerous instances were identified where, because of undue influence on the appraiser, values were increased without supporting documentation. And then also, the OTS investigation also concluded that Washington Mutual was not in compliance with the Uniform Standards of Professional Appraisal Practice and other minimum appraisal standards. And that's what we're alleging in this complaint. I'm going to scroll on. Okay, we come to the statute of limitations. Injury discovery is the default method of statute of limitations accrual in many federal actions, including RICO. There's the case site. And then, under injury discovery, an action accrues on the earlier of the date on which the actionable injury in fact is discovered or should have been discovered by exercise of reasonable diligence. The accrual date triggers the statute of limitations, which is 4 years from the date the plaintiff knew he or she was injured. In other words, the statute of limitations is suspended or tolled until the plaintiff knows that he or she has an actionable injury in fact and then has 4 years to file suit. We're going to scroll on. We're going to go all the way down to page 27. There's lots of good stuff and none of it's light reading. It's all on point. But what we want you to know is if you at least think that you have an actionable injury in fact. And so we're going to go here beyond the alleged misconduct. We're going to the basis of alleged liability. And this is really what you need to know, or at least this provides the basis for you to know whether you have a cause of action. The defendant's false representations are the actual and proximate cause of damages to plaintiff. The United States Court of Appeals for the Sixth Circuit explains plaintiff's theory of damages in the case In re Sally, case site, as follows. In Kentucky, when a party is induced by a fraudulent misrepresentation to enter into a contract, that party must elect to either 1. Affirm the contract and recover damages in tort for the fraud, or 2. Disaffirm the contract and recover the consideration with which he has parted. Case site. Quote, the election required is between the available remedies, either affirming the contract and claiming damages or rescinding the contract. Under Kentucky law, as found by the majority, the Sallies may recover the difference between the value of the property as it was fraudulently represented and the actual value of the property. Rescission of contract is not a meaningful remedy in the context of defendant's predatory scheme of inducing plaintiff to sign a promissory note and a mortgage exceeding the value of the subject property. Plaintiff therefore elects to affirm these contracts and recover damages in tort for the fraud. Accordingly, plaintiff seeks to recover the difference between the value of the subject property as it was fraudulently represented and the actual value of the property at the time of the signing of the loan and mortgage contracts. Defendant represented the value of the subject property at the time of the signing of the loan and mortgage documents as bank representation. See Exhibit 14. The property appraiser, or county name, county, assessed the value of the subject property during the year of the loan as, and then the assessment amount. See Exhibit 15. The county appraisal of the value of the subject property is a public legal appraisal reflecting the government's position on the actual fair market value of the property during the particular year at issue upon which the county property taxes are assessed. The government assessment of the value of the property is consistent with the 110-year mean for housing prices as adjusted for inflation of the currency. See Exhibit 13. Defendant's representation of the value of the subject property is inflated egregiously above the amount of the county appraisal. The difference between these two amounts is the difference. The actual damages in the amount of the difference are triple under civil RICO to the amount of civil RICO damages. The mortgage loan is called the benefit of the bargain, which must be repaid when affirming the contract and claiming damages for fraud and inducement. The balance of the loan amount is set off from the RICO damages and credited to any existing mortgage loan balance. The loan amount to plaintiff was the amount of the loan. The balance of the loan and the amount of the loan balance is subtracted from the RICO damages as a set-off, thereby satisfying the mortgage or thereby leaving a balance of the net balance to satisfy the mortgage. Defendant is liable to plaintiff in the amount of either the RICO damages minus the loan together with satisfaction of mortgage, or RICO damages minus loan as a set-off against the loan balance, resulting in a net balance of an amount, together with reasonable terms for plaintiff to satisfy the balance of the mortgage. I'm going to scroll through to the end of the complaint here just to show you what we ask for in remedy. Here we are, the request for relief. Wherefore plaintiff demands judgment against the defendant for actual, consequential, and potential damages, together with discharge of the lis pendens, vacation of final judgment, and of course you insert that only if it applies, satisfaction of the mortgage, cancellation of the note, attorney's fees pursuant to the mortgage loan documents based on reciprocity of contracts, common law fraud, and Florida Statute Section 57.105, including sanctions for raising unsupported claims or defenses, and damages for delay in litigation, and repair of any damage to plaintiff's credit history, interest, cost, and such other relief as the court deems just and proper. Further, plaintiff demands trial by jury on all issues so triable by law. In closing, we want to offer a very special thank you to William K. Black for his contribution in the field of criminology on control frauds, which made the writing of this complaint template possible. Also, thank you all from Tools for Justice.